My name is Jaime Rios, and I am an Associate Justice of the Appellate term for the 2nd, 11th, and 13th Judicial Districts of New York State Supreme Court, and I am a former housing judge. I was appointed in March 1985 along with another 5 judges, and I served 8.5 years in housing court. It was a great experience.
Before you were appointed a judge of the housing court, did you practice in housing court at all?
Well, actually, I did in a kind of roundabout way. When I was a senior at Fordham Law School, we created a housing law clinic. The minority students at Fordham were affiliated with a program sponsored by ABC, which was called HELP, or the Help Center. We didn't participate in the Help Center, but we decided we would create on our own a quasi-help program by participating with legal services in the Bronx. So a number of us contacted the legal services office in the Bronx on Cortlandt Avenue and agreed to volunteer our time as interns in the office. We didn't receive any credit for it or any salary, but it kind of gave us an opportunity to learn about landlord and tenant law. After that, I practiced law with the Brooklyn District Attorney's Office for 2.5 years as an assistant district attorney. Then I was appointed special counsel to the Police Commissioner of New York. 2 years later, I was promoted to the rank of Deputy Police Commissioner. And while I was the Deputy Police Commissioner, I was the judge in charge of adjudicating cases brought against alleged impropriety by police officers. In other words, I was the trial commissioner who adjudicated misconduct by employees of the police department. So police officers could be fired on my recommendation. Civilian employees could also be disciplined on my recommendation. And I left that office in 1984 and practiced general law in Queens County, and I had certain cases that involved landlord-tenant law. While I was at the police department, someone recommended I apply for a position with housing court. And I really didn't feel comfortable about applying for the position because, frankly, I didn't have the expansive experience that my colleagues did, such as Peter Tom, who had worked as a law secretary, or others that had actually practiced landlord-tenant law on a daily basis. However, a year later, when I interviewed and I was told that my judicial experience, my ability to control a courtroom, to manage cases, to write decisions, was just as important as having some substantive law background, I was offered the position and I graciously accepted.
So where were you assigned when you started out?
Well, right here in 111 Center Street. And what was really interesting, and I look back on it, there were 10 judges appointed within a 3-month period of time. Wow. Of those 10, because we went from 20 judges.
It was an expansion at that time.
Exactly. We went from 20 judges to 30 judges. And of the 10 additional judges that were appointed during that 3-month span from January through the end of March, 7 ultimately were elected to the state Supreme Court, and 3 ultimately reached appellate levels. I myself, who sits on the appellate term, Peter Tom, who's on the appellate division, First Department, and Luis Gonzalez, who is the presiding justice of the appellate division, First Department. The other 4 judges that were elected to the Supreme Court, 2 are still on the bench. Joan Lobis, and the name will come to me, but you know, time takes its toll.
Along, right. Right. So what
and Janice Bowman, of course, that retired.
Right. So what was housing court like then in the middle of the 1980s?
It's nothing like it was today. I was telling Ernie Belzeguy, my former law secretary, who was the clerk of the housing court earlier, before we went on the record, a few stories. One of the stories that impressed me initially was the lack of concern about the breach of warranty of habitability by the bar. certainly many of the judges, before it was enacted in the real property law, had recognized the importance of conditions in premises as being a condition that would affect the payment of rent. I think it was in 1972 that they began to write appellate decisions about the breach warranty of habitability before it was enacted in statute. And I remember that whenever we brought it up in colloquy with the landlord bar, they looked at the judges as though we were raising a topic that was inappropriate. I remember one instance when an attorney representing an established landlord-tenant firm here in Manhattan basically said to me, "Why don't you come down from the bench and stand next to the tenant and be the tenant's lawyer, because you have stopped being an impartial judge of this case. You are now taking sides." And that was solely because I inquired, are there any repairs that are necessary? Now, I believe it's customary now to have cases conferenced and the question of repairs discussed before any stipulation is drafted and any final judgment in a non-payment case
In fact,
is
it's
entered.
now administratively required.
Well,
So,
it just goes
yeah.
to show you how far we've gotten. But I remember when I went out to Queens, that occurred in Manhattan very early in my career as a housing court judge. When I went out to Queens about 2 years later, the same thing happened. It was sort of like I was from a foreign planet. "Oh, you're from Manhattan. We don't do things like that here in Queens." As a matter of fact, the attorney representing the landlord had the temerity to sit on counsel's table and say something like, "Let me tell you how we do things out here in Queens." Certainly, I straightened that out right away, as I did the lawyer earlier in Manhattan, because one thing that I was taught by the experienced attorneys that had risen to the level of housing judge, those that were there when we got here, like Jay Dankberg or Ralph Sparks, taught me that the most important thing is to manage your courtroom and to remember who's in charge, and not to let anyone intimidate you, because if they intimidate you, they're intimidating the process, and as such, they're creating a lack of justice in the court. So something I learned, and I'm very grateful that I've carried to this day in Supreme Court and on the Appellate Court, that you have to be in charge, know what you're doing, and not let anyone attempt to usurp your role as the manager of that courtroom.
At the time that you began sitting in housing court, what kind of staff did you have available to help you in the courtroom?
That's interesting. Well, first of all, you have to recognize that the people who worked in housing court were superstars because they were multitasked. They could do a lot of things at the same time. So we had a court officer, and the court officer served as the clerk, as the operator of the tape recording machine, as the guard at the door, as security for the people that sat in the courtroom. Often they had to step out into the hallway to manage the ruckus that might be developing out in the courtroom. So the court officer really wore many hats. We had a court attorney that was assigned by OCA or whoever was the administrative judge, and they could rotate every 6 months. I believe they rotated every 6 months. And you had no choice as the judge as to which court attorney you received. My first court attorney, I said to the administrative judge, "Please give me someone who's experienced, because I don't want someone learning the job as I'm learning the job as we go along. So make sure." Actually, it wasn't that difficult because, as I mentioned, I had mentors like Jay Dankberg and Harriet George and Ralph Sparks, who basically helped me with the substantive aspects, and procedurally and management I already had that. Another great judge was Andrew Markey, who also was very helpful. Tony Brandveen, was also very helpful in those beginning days. But this is a quick learn. It's sort of like you're thrown into the water, there's sharks all around, and you better learn how to swim real fast, and which I think I did. And of course, our administrative judge Judge Rubin was very helpful throughout the process. As time went on, another thing that was lacking, strangely enough, was the availability of Spanish language interpreters, which was shocking when I got out to Queens. In about a year and a half, 2 years, I was transferred to Queens, and when I got out there wasn't an interpreter for the Spanish language. And what was surprising was that Queens County had such a diverse population and a significant presence of Spanish-speaking citizens, naturally tenants. Naturally, being immigrants, that might have impacted on their economic situation, so naturally we had at least 20 to 25% of the calendar involving individuals who could use the assistance of an interpreter, and we didn't have one. So I was grateful that through my suggestions that we were able to get full-time Spanish-speaking staff to assist in the resolution of those cases. But before I got out to Queens, it was a rather difficult thing. As a matter of fact, we didn't even have a Spanish-speaking court officer. So those are some changes that I recognized were needed immediately when I got out to Queens, and we're talking about 1987. But I'm pleased to say that that has changed, and right now, if you need a Korean language interpreter, a Farsi interpreter, Mandarin interpreter, you name the language, OCA is now able to produce one within a relatively short period of time. And that's a benefit for the resolution of cases.
Do you think that, you mentioned what a struggle it was to start talking about apartment conditions. Do you think that over the course of time you were able to become effective in getting repairs made in apartments?
Well, I think so, because one of the things that I used to do, which was my habit, was I would make on-site inspections right after work. For example, a typical dialogue would be something like this. Tenant would say, I have no running water in my apartment. The landlord's lawyer would say, Judge, the tenant is lying, they want to avoid paying the rent. And my response would be, fine, I'll be there in 1 hour. I'd ask the court officer to arrange for a court reporter, for the court officer to notify security, and we'd all pile into my car, the reporter, myself, and we would drive to the location and conduct an on-site inspection with the court reporter taking notes as to what we observed. And we did that on numerous occasions throughout the borough of Manhattan. And I think that after a while, the attorneys get to know your modus operandi, and before they say that the repairs have been done, they actually try to find out for sure, because they know I'm going to make an inspection on site.
Were you ever assigned to an HP court?
No. I only stayed in Manhattan about a year and a half, 2 years, and when I went out to Queens, there were only 3 judges. Actually, there were 4 judges. 3 handled all trials, and 1 handled HP. That was Judge George, Harriet George, who retired about 5-6 years ago. But the other 3 judges handled the entire calendar. And again, even in Queens, I continued my on-site inspections because I thought it was important not to leave it to the inspectors to tell us what the conditions are, not to leave it to landlords to say they were being denied access, or to tenants to say that the landlord didn't come. Let's go and see for ourselves, if possible. So if it was an inconvenience that we had to go at 6 or 7 o'clock, I didn't mind. I wasn't being paid any overtime, and I'm sure the court officers appreciated the added benefit.
Sure.
Also another thing that I made mandatory was that all of my stipulations needed to have a statement about the condition of repairs. And I explained to the landlord bar that it was helpful to them, because if we put in there whether they want repairs or not, whether conditions of disrepair exist or not, then a tenant down the road couldn't allege a breach of warranty of habitability, because they could be, I forget the word, but they could be shown up for not having stated that earlier. It would impeach their credibility.
You mentioned the expansion of access to interpreting services. Were there other changes that you noticed over the course of the time that you served in the Housing Court?
Well, I think the most important change, and I think we'll all agree, anyone who was around in the 1980s when I started would agree that the court itself has been given greater attention, greater prestige. What do I mean by that? Well, when we came on board in the 1985, some of the existing judges had been concerned about a statement made in an appellate case. In an appellate case, a court had said that housing judges weren't really judges, that they were referees of long-standing tradition. And it kind of suggested to the practicing bar that we were less than judges. And that was that sentiment there. And certainly when you looked at the physical conditions, we had courtrooms that possibly were 8 by 8 or 10 by 10, smaller than a small bedroom in a typical New York apartment, where possibly only 2 or 4 litigants could sit at a time, and everyone else had to wait outside. So I think that indicated the type of importance the court had. There weren't really any resources, so we had a small staff. The courtroom was small. There were no court reporters. There was a tape recorder. The tape recorder was the cassette type. If it operated, it did. Its effectiveness was questionable. And I think that kind of transmitted a message that this isn't really a court of law. And I think now, when we've seen the expansion of the court, that we have so many resources, we have resolution parts where cases are conferenced, where conditions of disrepair are taken into consideration, where tenants are afforded an opportunity to consult with pro se clerks, where things are explained to them in their native language to the best of our ability. After all, we're not their lawyers, but we have an obligation as a public entity to encourage them to pursue their rights and to explain their rights to them. There's more transparency in the court system. And I think all of that has been helpful. And I think the type of people that we have now are people that really want to work in the courts. Court attorneys who understand the ramifications of their role, their actions. So if they give a tenant a short shift, they know that this tenant is facing homelessness, and they empathize with their plight. And the judges who recognize the rights of landlords, the small landlords who have a need to pay their mortgages and to meet their obligations, pay their taxes. So I think there's a greater balancing today because of the increase of resources, because of the improvement in the facilities. And I think the landlord bar has grown, that they recognize their obligation is more than just an obligation to a client, that there's an obligation to the profession. So I think that in the 27 years since my appointment to the bench, that there have been leaps. We've grown tremendously. I think the new housing court in the Bronx is a step in the right direction. I think the new wing of housing court in the civil court building in Queens County is a tremendous improvement. The facilities are wonderful. The courtrooms are spacious. So I think we've come a long way.
You think that the court has a higher level of respect in the broader community than it did?
I think that the court always had a high level of respect, but there were some dissenters, if you will, some who thought that the court could be bullied. And I think with time, through the leadership of the judges and their administrative judges, we've shown the bar that our judges are top quality. As a matter of fact, one of our alums, she came on afterwards, Judith Gish. Not only did she achieve Supreme Court, but she's now on the Appellate Division. So I think that we have many of our judges who have demonstrated through their writings, through their jurisprudence, the talent that housing court has attracted over the years and will continue to attract.
So from where you sit now, you have an opportunity to review a number of decisions coming out of the housing court. So you have sort of a different perspective from which to observe it. What do you notice as an appellate judge about what comes to you out of the housing court?
Well, one of the things that we see is that there continues to be a difference of interpretation in the law between the First Department and the Second Department, which necessitates the intervention of the Court of Appeals. I always found that like minds will have reasonable differences. So it must be a problem for judges that travel from Manhattan to Brooklyn. They have to remember which department they're in. And
when we have training, we are constantly talking about the First Department and the Second Department and the issues that come up.
But I think that's good because, after all, that means that our housing judges are students of the law. They recognize that appellate review is a fundamental aspect of the process, and their being aware of it makes them better judges. And ultimately, they become better judges when they move up, because all of our judges, from what I've seen in the last 25 years, move up. They go from housing to civil to supreme to the appellate division. And I'm sure any day now we'll have one of our own on the Court of Appeals.
I guess it speaks well of the selection process if our judges are doing that well.
Well, I think not only the selection process, but I think the camaraderie of housing judges, how they go out of their way to help each other, to support each other, makes them better judges as well. And I'm so grateful to judges like Peter Wendt and Peter Tom for helping me write better decisions.
So anything else you'd like to share with us about your experiences in housing
I could
court?
talk about housing court forever because it's such an important part of my judicial background. One of the great things about housing court is that you don't have to retire. There's no mandatory retirement unless they've changed that.
No.
So we don't lose the talent that we nurture and develop. That if they choose to remain in housing court, like our supervising judge in Queens County, Gilbert Berdillo. He's been a housing judge, I think, for more than 20 years, and he has no interest in going to civil or supreme. He's very happy doing the Lord's work in housing court, and he plans on staying there until his hair turns grayer. Did you
develop skills in housing court that helped you in your later career?
Of course. One of the things that people are amazed at when I conduct inquiries in Supreme Court, when I question lawyers at the appellate court, is how I'm able to phrase questions, to identify issues so quickly. And it all comes from my housing court training, where it's right in front of you. There's no jury. You have to be the judge and jury. You have to explain things to pro se, self-represented people. You have to understand the legal argument. You have to understand the precedents that are being argued by one side and not the other, and be able to read that precedent, extract the issue, the holding, and apply that principle to the facts in hand. One thing I didn't mention earlier, which was great about housing court, was how in the middle of a trial, a clerk would walk in with a stack of orders to show cause. And in the middle of your trial, you would be reading orders to show cause applications to vacate default judgments and the like. I'm happy to say that my understanding is that that process of interruption has changed, or at least I hope it has. But certainly the training in housing court is an invaluable experience no matter where you go in the judiciary, whether you go to criminal court or civil court. If you work in small claims court, housing court is quite alike small claims court. You sometimes have self-represented individuals, and you have to be able to communicate with them, explain things to them, and certainly that's one of the most important aspects of housing court, ability to communicate.